What is the expected impact of the European Artificial Intelligence Regulation on financial markets? I present myself, I'm Giulia Schneider, I'm Assistant Professor in Economic Law at the Catholic University of Milan and Professor here at the Florence School of Banking and Finance. So in order to answer the question of the impact of the European Artificial Intelligence Act on the financial markets, one has to go back at the very objectives of the regulation. On the one hand, to promote innovation while safeguarding citizens' and consumers' fundamental rights. So the European Artificial Intelligence Regulation is meant to be a horizontal regulation because it intends to apply and to regulate artificial intelligence systems which are employed across the various sectors of the internal markets while protecting personal fundamental rights of citizens. So how is financial artificial intelligence systems regulated by the regulation? Now, first of all, one has to remember that in accordance with the risk-based approach of the European Artificial Intelligence Regulation, the European regulator has identified some typical cases of financial artificial intelligence use cases which are to be considered as high-risk system. This is the case of a financial credit scoring system and health and insurance scoring systems. These systems are thus to be considered as admitted in the internal market, but provided some specific requirements are met, which the regulation lays down for high-risk system as transparency requirements, technical documentation requirements, automatic logging requirements, the requirements of human supervision. Now, in accordance with the risk-based approach that the European Artificial Intelligence Act lays down, actually most of financial AI use cases appear to fall in the category of low-risk system, thus systems which are to be considered as fully admittable and marketable in the European internal market without any safeguard, without any requirement. Actually, the last version of the Artificial Intelligence Act has opened its regulatory scope by introducing some requirements which are actually meant to become applicable to artificial intelligence systems, also disregarding their risk impact on the protection of personal fundamental rights. Article 4 of the European Artificial Intelligence Regulation now introduces a literacy requirement, namely a requirement for both providers and users of also financial, thus artificial intelligence systems, to have adequate skills, competences and knowledges about the potential risks of the employed or provided artificial intelligence systems, and thus this requirement is to be considered as a primary importance also for financial intermediaries which either provide or use artificial intelligence systems. In second stance, the Artificial Intelligence Act in its latest version lays down also requirements for so-called general purpose AI system directly targeted to providers. Providers of general purpose AI system have to undergo a strict examination of their systems that they are marketing, so in order to identify whether the general purpose models have a systemic risk, a systemic impact or not. And in accordance with this, the existence of a systemic risk, the providers of general purpose models have also to fulfill some specific requirement in terms of heightened transparency and documentation requirement. Also, the provisions regarding general purpose AI systems and models actually are of high relevance to the financial sectors, given the large employment in financial sectors of these types of models. This means that financial intermediaries, once they use in accordance with outsourcing agreements, general purpose AI model, they have to verify that the providers fulfill the requirements. But as I was saying, beyond these requirements and beyond the strict cases of financial credit scoring and health and insurance scoring, most of the European financial artificial intelligence systems actually appear to fall outside the scope of the the AI Act. So what lies ahead? Financial supervisors in particular will have to develop some autonomous and sectoral regulatory and supervisory policies regarding financial AI system with specific regards to the economic risks that this system may pose in terms of financial stability and in terms of market integrity. These are interests that for now the European Artificial Intelligence Act doesn't consider, because the European Artificial Intelligence Act targets only the protection of personal fundamental rights. This is actually to be considered a missed opportunity, because the European Artificial Intelligence Regulation as such is, yes, a horizontal regulation which applies in accordance with a risk-based approach, but it is not a holistic approach. It leaves out the protection of economic rights, which financial supervisors are called now to develop and to target, to address in accordance with specific and targeted regulatory and supervisory policies. Maybe the tool of the development of codes of conduct, which the European Artificial Intelligence Act actually calls upon, will be a useful tool in order to have a first soft law regulation of financial artificial intelligence systems.